Hello everyone, I hope I am audible, and in this video I will basically try to make you understand a judgment that I have read right now, and it is telling something. It is somewhere related with the accidental claim. Okay, and I hope I will make you understand this thing. Split multiplier cannot be applied unless specific reasons given. Now the Supreme Court is saying to the High Court that you can't give the compensation in the form of split multiplier. Now what is the split multiplier? We have to understand the concept split multiplier with the multiple or multiplier of dash. Okay, so there are two concepts. First, multiplier of dash, as well as the another one is split multiplier. This is very technical. Multiplier of dash means you are putting an age and assuming that the person who died gonna leave that year. Okay, for example, multiplier of 10 means we are assuming that कि मृत्यु के 10 साल बाद, ठीक है, वो जो 10 साल का पीरियड है, आज मृत्यु हुई तो आज से लेके 10 साल. ओके, मल्टीप्लायर ऑफ 15 मृत्यु के 15 साल बाद तक. मल्टीप्लायर ऑफ 20, ठीक है, मृत्यु के 20 साल बाद तक. ठीक है, सो दैट इज मल्टीप्लायर बाय डैश. ऑन द अदर हैंड वी हैव split multiplier. Now in split multiplier what happens that we split the income that a person is earning in two or three portion. In first, the actual income that the person is earning. In second, the income that the person will earn when his income will get increased, and that amount that the person will earn that duration. And the third one, that he will receive as somewhere as an award or as a pension. So that will be another portion. So in three portion we have splitted the salary of that person. So this is split multiplier. Okay, we are splitting the income of that person on basis of his performance, his increment of salary, his retirement, and then what he is getting, any other extra incomes. So in these things we are basically splitting. But on the other hand, multiplier of dash means we are assuming that we have to put a value, and that year the person gonna leave, or that year the person gonna earn. This will be more suitable, that the person gonna earn. So this was the difference between split multiplier and multiplier of dash. Now in place of multiplier of dash we can put different values on basis of age, like 10 to 15-year old. If there is a person who was 10 to 15-year old and the person died, the multiplier will be somewhere 20, something like this. And as the age will increase, the multiplier of that digit will decrease. Okay, so there is a chart, proper chart, and on basis of the age, the term and the digit we use in multiplier of dash wala concept. And on the other hand we have a split multiplier. Both are different things. Now what let's continue where we left. What Supreme Court said, or advised to the Honorable High Court, that the court must apply the multiplier of dash wala theory and the procedure for calculating the compensation, not the split multiplier. And if court wants to use the split multiplier, then they have to give a valid reason that why it is required to use the multiplier of dash wala compensation method. Okay, now let's continue. A bench of Justice J.K. Maheshwari and Rajesh Bindal of Supreme Court. So these were the honorable judges, justice, who who were in the case, who were dealing this case, and this was his their observation that the High Court, the High Court didn't follow the rule for compensation, for creating, for making a compensation by the High Court. Uh, a court did not follow, yeah, that a court must follow the Sarla Verma judgment, in which it it has been given that the court should focus on multiplier theory for calculating someone's income, and for the compensation thing, and not the split multiplier. But if the court wants to use the split multiplier formula for calculating someone's income or compensation, then they have to mention the valid reason. In this case, Supreme Court said the High Court didn't follow the Salla Verma judgment and made the compensation in the form of split multiplier, and not in the form of the multiplier of dash, which is not right. And the Supreme Court said if a court wants to use the split multiplier formula, then they have to give a valid reason. Now, on basis of that, Supreme Court overruled the High Court judgment and entitled the total compensation of 33 lakhs rounded off to the plaintiff. Okay, now let's understand the facts on record of the facts of the matter, facts of the case. Okay, on 7th March 2020, 7th March 2014 at 3 p.m. a person was traveling with his son in a bus, on a bus, and he came out on a bus stand. When the bus stopped, he came out, and while mm, he was walking, a bus hit him, and he died because of that injury, the person. Okay, let's assume the person X. Okay, and the person X was traveling with his son, and because of the hitting of the because when he was on road, and because of the dash of the bus, you know, dash means dhakka. So because of the dash of the bus, the person died because of getting that injury. The family went to the tribunal for asking the compensation, and tribunal, when the matter went to the tribunal, so first thing was the driver and the owner of the bus didn't appear in that matter. So after the, despite the services, despite the summon, the driver as well as the owner didn't appear. So the court continued the case ex parte, means without um, in the absence of the party, in the absence of the driver, in the absence of the owner of the bus, assuming that they intentionally wave off their chance. It's so loudness in the backside. Okay. So the owner and the driver didn't appear. The court mm, um, continued the procedure ex parte, means assuming that the person intentionally waived off their right to appear in the court, and continued. On the other hand, the insurance company was appeared there, and company inter alia, means since starting, that the uh, denied the fact that there was the negligence of the driver, and apart from that also denied that the amount that the appellant is asking for is huge amount, and is not justificable amount or justified amount. It should be lesser as compared to ask for. Now, after hearing of the both party, the tribunal assessed the compensation at 28 lakh 66,994, which makes the rounded figure of 29 lakh. In this 29 lakh, if we will break up the amount, the loss of dependency was 27 lakh 41,994, which makes it the round figure of 28 lakh. Now, in this 28 lakh, the court assumed that 4 lakh 57,000 is the person annual income. Okay, and then with that amount, the court multiplied it with 9. Okay, as the rule of multiplier of dash says. So, annual income multiplied by 9 into 2 upon third. Now, what is 2 upon third? There were three members. There were three members who were dependent on the disease. So on basis of that, it should be splitted. So annual amount, then into 9. The 9 come from the age factor, the chart, age factor chart, and on other side we will see the uh, digits, that is 15, 12, 10, something like that. So annual amount multiply by 9 into dependent person, that is 2 upon 3. 2 third, basically, sorry, I am somewhere, I have to correct it. 2 third is basically the income that the person will spend on his family. 1 third he will keep it for himself, and the two third he will give, invest in the family and give to the family. So that is 2 upon third. So 4 lakh 57,000 into 9 into 2 third makes it 28 lakh, lump sum 28 lakh, which is in rounded figure. Loss of consortium to wife, means the uh, it is the basically price of emotion that the wife is going through. The court said it should be 1 lakh. Funeral expense 25,000, and the total makes it 20 on and round figure 29 lakh, with 7.5 per annum interest. So tribunal allowed the 29 lakh with 7.5 percent interest rate, if the respondent doesn't give the amount. Now what happened? Not satisfied with the tribunal's decision, the respondent approached to the high court, and in high court, the high court, honorable high court, reduced the compensation under the head of laws of dependency. Okay, and then the court, honorable high court, also reduced the consortium loss of consortium to wife from 1 lakh to 40,000, and the total amount of compensation assessed by high court was almost 20 lakh. In this 20 lakh, The court used the formula of split multiplier, and Supreme Court, when this matter will go to the Supreme Court, the Supreme Court will say that you can't use generally split multiplier without having a valid reason. Okay, so you must have valid reason. Now by using the split multiplier, the Honorable High Court said the compensation will be salary of a person from March to December, 2024 2014 March to December 2015. Okay, and the salary will be with the rate of 39,500, calculating with, that is 22 months, it will be 8 lakh 69,000. Then the salary of from from January 2016 to July 2016, where the person's salary has been increased from 52,500, and the month is total month is 7 months, which makes it 3 lakh, almost 3 lakh. And the person's pension would be with the rate of 21,250 multiplied by 79 months, that is 16 lakh 78,750. Dependency, if we will reduce the dependency of self, then it will be one third, and the two third will be go to the party. So in this, they reduce the dependency of one third, that makes almost 10 lakh. So the total income, in that total income, the dependency of a person will be deducted, and then the remaining amount will remain, and the remaining amount will be given to the family. Loss of estate means whatever the person would have invested or gained from another factors, allowed the 15,000, for funeral expense 15,000, and for loss of consortium where tribunal had allowed for 1 lakh, here the Honorable High Court allowed and made it 40,000. And the total amount which the High Court, as which the High Court assessed was almost 20,000, or sorry, almost 20 lakh. Okay, so the total amount that tribunal allowed was 29 lakh, and the High Court allowed was 20 lakh. Then, not satisfied with the decision of the High Court, the plaintiff approached to the Honorable Supreme Court. Now in this Supreme Court, that is the operative part, what was the observation of the Supreme Court? Considering the aforesaid factual aspects and position of law, in our view, the compensation on account of loss of income while applying the multiplier of 9 by the tribunal without applying the split method is the correct calculation on that account. So here the Supreme Court is directly appreciating the tribunal that they use the valid valid formula, that using the multiplier of 9 instead of split multiplier formula. And then considering the age of the disease, so multiplier of dash, that here multiplier of 9, this factor, the 9, come from considering the age factor of the disease. So considering the age factor of the disease, the appellant would be entitled to future prospect 15, at the rate of future 15%, 15%. Okay, this was the additional thing that the Supreme Court added, that we also have to see his future thing, and the amount, whatever amount it will be, the tribunal must figure it out that the interest of on that amount there, in at the rate of 15% should also be given. A lot of noise is coming, I'm so sorry. Sorry for the inconvenience. Let wind up the case. I hope, where should I keep this? So Supreme Court also add the 15%. Apart from that, on account of loss of estate and funeral expenses, the amount of 15,000 each awarded by the High Court is as per the law. Apart from that, Supreme Court said that the funeral expense and the loss of estate, that is 15,000 for each, awarded by the High Court, is as per law. That is fine. They would be entitled to compensation on three claimants, namely the widow, one son, and daughter. The Supreme Court also said there will be three claimants, so the loss of consortium, because not a single person suffered from the have had been gone through the emotion, but all of these three. So the loss of consortium will be 40,000 each family member. The tribunal had in awarding only a sum of rupees 1 lakh in total. This means the Supreme Court said the tribunal made only a single mistake, that they given the total 1 lakh compensation as an loss of consortium. That should be 40,000 per head. That gonna be make 1 lakh 20,000. So on in the opinion of Supreme Court, the total amount should be loss of dependency, in which the Supreme Court assume that 4,57,000 will be the annual income of that person, multiply by 9 come on basis of his according to his age, 9, then 2 upon 3 is the amount that gonna be given, or that would the person will would have been given to the family, 2/3, and into 115 upon 100, which is 15%. As Supreme Court added that they said they shall also get the 15% for the future, which makes it total almost 31.5 lakh. Loss of consortium, as I have told you, 40,000 per head, means 40,000 into 3, that is 1 lakh 20,000. Funeral expense 15,000, loss of estate 15,000, which makes it total 33,000, 33 lakh 3,300, which makes it overall rounded figure of 33 lakh. For the reason mentioned above, the present appeal is allowed. The impugned order passed by the High Court, and with this only, the Supreme Court set aside the High Court judgment, High Court order, and also advised the tribunal to modify its order as mentioned above. Above, the appellant are held to be entitled to total compensation, and allowed the appellant to entitle to the total compensation of 33 lakh. Also said that the payment shall be entitled to the appellant with the interest of the same rate as was awarded by the tribunal, which was the 7.5% per annum. The name of the case is Maya Singh and others versus the Oriental Insurance Company Co Limited and others, civil appeal number 2020 2203 of 2025. So this was the case.